And thank you for joining us for the April's committee meeting. And before we begin, Ms. Wong, could you please take roll?
Sure. Dr. Bolton,
Here.
Judge Brody,
Here.
Dr. Kao,
Here.
Mr. Chen, Mr. Efting,
Present.
Mr. Gongora,
Present.
Ms. Heisinger,
Here.
Judge Herman,
Here.
Mr. Iseri,
Here.
Mr. Kaplan, Mr. Kramer,
Here.
Mr. Lawrence, Mr. Lawrence,
Here.
Ms. Pick,
Here.
Mr. Reyes,
Here.
Judge Toriaba,
Here.
Mr. Torres,
Here.
Dr. Wilkinson.
Here.
We have a quorum.
Thank you. And now will be our time for public comments as noted on the agenda for today's meeting. Public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. For those who did, we thank you for that. We will attempt to call members of the public in the order that they appear. And right now, how many do we have, Ms. Wong?
We have currently 3
Okay.
public comments.
Based on the number of people that will be requesting to make public comments, we ask that you limit your comments to 2 minutes. And to facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. To allow the committee the time needed to deliberate on the important topics that it will be discussing today, we will not be able to hear more than a maximum of 15 minutes of total public comments. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify their raised hands and will enable the microphones of the speakers. Ms. Wong, could you please call the first speaker?
Yes. When I call your name, I will indicate when you have 30 seconds left. Please wrap up your comments then and within your allotted time. So for now, let's begin with Dean Freiberg.
Good morning, members of the committee. My name is Jay Frickberg. I'm the Dean of the University of West Los Angeles. I'm also one of the co-chairs of the CALS, the Association of the California Accredited Law Schools, and I'm also one of the CS BAR's committee members. First, I'd like to say thank you to Natalie Leonard and staff. As we discussed in CS BAR's, I think the approach to agenda item E is well thought out in an attempt to resolve the mathematical equivalent of a Gordian knot here, as we're trying to determine what is the most transparent and accurate way to measure for the public. I would ask on behalf of the CALS, if you would please consider and discuss the public comment that was submitted in writing by the CALS. And I would also, on a personal note, like to point out that I think that the major distinction that we are left with resolving for your discussion today under agenda item E between CALS option 2 and the CBE staff option 2 discussion is whether or not we follow the ABA model of counting someone who enters the PLP as a passer as they enter, or under the staff proposal, we count that person once they've satisfied the PLP requirements. Thank you.
Thank you, Dean. The next public comments is Dean Gardina.
Thank you, and thank you, and good morning to members of the committee. I'm here to speak as the chair of the Committee of State Bar Accredited and Registered Law Schools on educational standards item A and E. First, as to item A, I want to again thank the members of our committee, both past and present, as well as the State Bar staff who played such a key role in developing the proposed accredited law school rules. It was a momentous task, and I believe the proposed rules reflect best practices in accreditation with a strong focus on a quality legal education and importantly on issues of diversity, equity, and inclusion. CS Bars reviewed the technical amendments that were presented to the CBE last month. We were able to review those on Wednesday and have recommended that the full slate of rules move forward to the Board of Trustees with one amendment, which is to remove the language that was inserted into 4.172 because it is redundant and added confusion. So I'd ask that the CBE move the rules to the Board of Trustees as recommended by CS Bars. Second, I'd like to speak directly to item BE, which is the calculation of the NPR. I realize that this is an incredibly complex issue and that the CBE is balancing statutory requirements, Supreme Court guidance, accreditation standards, and the State Bar's own mandates regarding consumer protection and transparency. On Wednesday, the CS Bars voted to recommend what is labeled option 2 under the CAL's public comment. CS Bars believed option 2 best balanced the sometimes competing mandates the CBE is facing. And it's also consistent with how ABA schools have been told to report their bar pass rates. The ABA accredited law schools were informed by the ABA that the bar applicants entering the PLL pathway should be included in the school's bar pass rate calculation to reduce consumer confusion and to allow for consistent transparency. We hope that the CBE will take the CS Bar's recommendation. Thank you very much for your time.
Thank you, Ms. Dean Gardina. The next public comment is from Dean Winnick.
Thank you very much. Good morning. My name is Mitch Winnick, and I have the pleasure and honor of serving as the President and Dean of Monterey College of Law. As you've heard, later on today's agenda, you'll be asked to consider how to apply the new 1390 cut score to guideline 12.1 of the accredited law school rules. I served on the law school subcommittee that drafted this guideline. It's intended to protect the public by providing a very simple, transparent, and easy to understand score that reflects one simple calculation. How many of a law school's graduates sat for the California bar exam, and how many of those examinees achieved the exam score set by the California Supreme Court. The 12.1 calculation is not intended to measure which graduates passed the MPRE, received a positive moral character determination, completed supervised practice, paid their bar dues, or ultimately are admitted to the bar. Those items are properly addressed and reported under other rules and statutes. Guideline 12.1 does one simple and important thing for the public. It reports how many graduates took the bar exam and achieved the exam score required by the Supreme Court. The court adjusted that exam score to 1390 for examinees starting with the July 2015 bar exam. Although the court has also ordered additional bar admission requirements for these graduates, these requirements, such as 300 hours of supervised practice, are not part of the 12.1 calculation, simply because they are not part of the bar exam. Today should be a very simple decision for this committee. Please authorize the CBE staff to report to the public how many examinees of each law school starting in July 2015 achieved the 1390 exam score set by the Supreme Court. Thank you for your time.
Thank you, Dean Winnick. The next person is Dean Liu.
Say good morning, everybody. I'm George Leal. I'm the Dean of the Irvine University College of Law, and I'd like to speak briefly in support of the staff's recommendation for your agenda item D this morning. That item relates to a request submitted on behalf of my school and a number of other registered fixed facility schools asking that the committee take action to extend its current waiver, allowing my program and the program of other schools similarly situated that would otherwise be taught in the classroom to continue as they have for the past year through an online program on Zoom. I think we could all agree that the news lately with regard to COVID and the pandemic is good, particularly here in California. But the point I've made and other deans have joined in is just the degree of uncertainty that remains, and I think will still be with us throughout the end of this year, and hopefully not beyond that, such that we're all small schools. We don't have, frankly, the resources or the ability, as we've probably seen recently, the CSUs and UCs, major educational institutions being able to mandate vaccinations or carry out testing programs. Our program has worked exceedingly well, almost surprisingly. It's well regarded by my faculty and staff. Many of them are quite grateful that we're still very much in business. They're able to advance in their legal educations. Our professors can still teach all remotely, and it's worked quite well. And so I think the other deans would agree with me that at least through the end of the year, it makes no sense. And it just, at this point in April, it's exceedingly difficult for us to know where we'd be in August when the current waiver terminates. So in that, I'd like to also thank Ms. Leonard and staff. Their agenda report, item report was exceedingly well documented. And I hope the committee read it and considered it and has had a chance to read our public statements and accept the staff's recommendation. For that, I thank you for your time and appreciate the opportunity to speak on behalf of my school and the others. Thanks.
Thank you, Dean Leal. At this moment, Ms. Chair, we don't have any other public comments.
Thank you, Ms. Long, and thank you for everyone that spoke today for public comments. Moving on to the next item, it is the March 26, 2021 meeting minutes. If no one has any questions, then is there a motion to approve?
I'll move to approve those minutes. This is Robbie.
Thank you, Robbie. And
This is Kareem.
I'm sorry, Kareem, you seconded?
Yes.
Okay, thank you, Kareem. Roll call vote, please.
Sure. Dr. Bolton?
Here.
Yes or no?
Yes.
Judge Brody?
Yes.
Dr. Cow?
Yes.
Mr. Efti?
I'm going to abstain because I wasn't there.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Toriyaba?
Yes.
Mr. Torres?
Yes, I'm sorry, abstain.
Dr. Wilkinson?
Yes.
The motion passes.
Thank you. And now I will turn it over to Amy.
Good morning, everyone. I'm going to start with the report on key statistical indicators. This is a highlight of applications that I'm going to report on highlights of anything with a 15% change that varies from the previous year. For this round of key indicators, this is reporting only for the month of March 2021. In terms of differentials, applicants placed on the motion, if you look, we have an 88% increase for the March of 2021 compared to 2020. And this is primarily due to the fact that the October 2020 bar exam, that postponement delayed the release to January 2021. So that it really inflated the number of applicants that are placed on the motion when compared to last year. In terms of registrations received, law students, we have 21% more this month than we did last year. For the general bar exam, 31% more. Attorney bar exam, 44%. And again, this is a timing issue. The postponed bar exam created a delay, and also the results release. So many applicants waited for the results release in January to apply for the February 2021 exam. And typically they would have had that, those results would have been released in November. As for moral character determinations, we have 18% more than in 2020, which may be related to provisional licensing. Lastly, the moral character determination extension applications, we have 17% more this year when compared to 2020. And the law office study program, we have 58% less when compared to last year in the month of March. Are there any questions about the key indicators? Okay. Then with that, I'll move on to the review of the June 18th and 19th, 2021 CBE meeting. This is going to be a 2-day meeting. It's currently scheduled as a Zoom meeting, and it starts at 9 on Friday and will continue on Saturday in the event that we have more agenda items to discuss. Any questions about that agenda? Okay, moving on then, we're going to go on to the updates on the Office of Admissions and State Bar activities. And with that, I'm going to ask, our first item on there is the provisional licensing program. And Kim, do you mind pulling up the PowerPoint? Kim?
Give me a second, Amy. Give me a second.
Great. No problem.
Amy, I don't see any PowerPoint right here. It's blank.
Okay.
Is it the same from the other day? You want me to share it, Amy?
You know what? I have.
Oh, I'm
Very
so
good.
sorry. Yeah, I'm having a problem with my screen. Give me a second.
Okay. Yeah, I think I have the same problem, and I thought it was because I was trying to read, but Zoom and PowerPoint are struggling at the moment.
I apologize. Just trying to make it as a presentation.
Kim, if you just hit the button that says from beginning, yeah, that should work. I feel like all the new versions of these programs are harder to navigate.
Yeah, they're not corresponding well.
No. Okay.
Does that work?
Yes. Can you
Okay.
see?
I think it will. It's just taking a moment on our end to broadcast. There we go.
Great. All right, so I'm going to give you a highlight of some of the current activities taking place in the Office of Admissions related to PLL. As many of you are aware, on October 22nd, the Supreme Court approved California Rule of Court 9.49, implementing the provisional licensure program, and that became effective in November of 2020. And since that implementation, the office has received over 2,000 applications, and I'll talk about the highlights on our statistics shortly. Also, since the launch of the program, the Supreme Court has approved 2 amendments to the California Rule of Court. The first occurred in January. The court approved an amendment to expand eligibility. And this expansion makes it possible for potentially about 2,000 bar exam applicants who achieved a score greater than 1390, the new cut score, either at first read or as a total scaled score between July 2015 and February 2020, the ability to serve as provisionally licensed attorneys. These candidates would be eligible for licensing after 300 hours of legal service provision, along with a positive referral from their supervisor in lieu of passing the bar exam. The provisional license program application for the expanded criteria became available in February of 2021. The next amendment happened in March of 2021. The court amended the rule to clarify the eligibility criteria for the expanded program, specifically that applicants who passed the bar examination but have not been licensed are not eligible for the program. And also applicants with an adverse moral character determination are not eligible unless more than 2 years have elapsed from the date of the final determination. Also, the court described the manner in which successful PLP participants in the expanded path will be treated in regard to Business and Profession Code Section 6060.
Can we make the that slide full screen? I can't read the numbers.
I'm sorry. I'm just having a hard time with my screen. I don't know what happened. So I wish I can expand it.
It's coming in. It's coming in good now.
Oh,
it's coming in expanded now.
I think the smaller slide's not gonna, the one with the statistics is not gonna show up unless you put this into slideshow mode. So Kim, if you're having trouble doing that, maybe Audrey could share, or Kim, you can try clicking on the slideshow icon, which is at the bottom right of the screen. It's the little like box with the stand on it. Do you see that icon there?
I did click. Something happened with my computer, and again, I apologize. I don't know what happened. I did click.
I see. Okay, well, maybe Audrey, if you have a copy of it, you could share on your screen. Because I don't think I don't know that there's any way to even blow it. Well, maybe you could blow it up by using the Zoom tool at the bottom right.
If we want to get technical, I think Kim's showing screen 1 rather than screen 2, because this is in slideshow mode. Screen 1 is defaulted to notes presentation, so that's why there's notes.
Oh.
So it might be screen 2 that she needs to show, but that's more complicated down the line. It's easy just to have someone swap out.
You know what? I have it pulled up.
I can share it too. Either way.
Okay. Kim, if you stop sharing, I will pull this up. Okay.
Sorry, Amy. I just know that those numbers are already kind of small.
Exactly. I hope this helps. Can you all see those numbers?
Yes, thanks.
Okay, my apologies. Let me pull this up so I can see. So as you can see here, what I have in front of you is the 2 sets of numbers. These are our status as of April 2021, April 20th, 2021. these are accounts and they're separated by the two cohorts that exist right now. Those that are participating in the PLL program based on graduation date, that is, they graduated between December 2019 and December 2020 is the left-hand column of numbers. And on the right-hand side, we have those that became eligible for the PLL based on the program expansion. We have a total of 782 active and approved PLL participants right now. I'm not going to go through each number, but I also want to point out that in terms of those that have been terminated, we have approximately 421 if you look at these statistics. Most of these have been terminated because PLLs, many have passed the bar exam and are now licensed. And others are in the termination status based on the fact that their positions have finished at the in their work environments, which vary from law firms to DA's office and so on. Also, if you look, we have about, in terms of our denials, we have 27 denials, and those are due to either the supervisor or the PLL not meeting all of the program requirements. So we have a grand total of, like I mentioned, over 2,000, so 2,123 applications that have come in so far.
Hi, Amy, this is Kareem. By any chance, do you have any demographics or background on these app participants?
No, we have not conducted that level of analysis.
Okay, I think I'm more interested in the CALs and seeing how many of those students are from there. Especially considering we have something on the agenda today, considering that. But hopefully, maybe we have that data.
Yes, Natalie will be speaking to that data shortly.
Thank you.
Sure.
What does drafted mean? That means you put together the report, but that hasn't been signed, sealed, and delivered?
Exactly. The application has been partially filled, but it has not been submitted, and the applicant has also neither paid for the application itself.
And what is your reaction to the numbers? Do you think it's more than you expected, less than you expected? Just curious.
Well, we had a sense of the number of people who would be eligible for the expansion program. I mentioned it was something like 2,000. One of the things that we've done is for those that have not applied, that are eligible, we've already sent notices to remind them that the registration for that application is at the end of May. May 31st is the last day that anybody could apply in the expanded category for that. So we're encouraging folks. So we're not surprised with the expanded numbers. Like I said, we knew who was eligible. In terms of graduation, we didn't have a sense of how many were on there. And so, yeah, I mean, we're more than anything, we're prepared for the numbers. We did what we could to ensure that we had sufficient resources in both our eligibility and moral character units to expedite these applications. All right, and the last thing I wanted to mention, and it's the last slide in here, and I'm hoping that I'll be able to share that well. It's really hard for the system for me to share screens and use Zoom, so give me 1 second. Here we go. All right, so my last slide here. All right, so the other two initiatives related to the provisional licensing program, we also launched the learning module system. As you might recall, there are two education requirements for PLLs. The first is if somebody had not met their MPRE requirements, they're required to take the 4 hours of the new attorney training on professional ethics. And so the learning module allows for that. And also all PLLs are required to take the new attorney training within the first 12 months. And so those the learning module system allows access to that. And so that launched in March. Now, the second thing we also have done is we we opened the system that allows the time tracking mechanism. So there's a time log that's part of the requirement. I mentioned that for those in the expanded pathway, once they serve 300 hours of legal service provision, they are eligible to become licensed along with a positive attorney supervising lawyer evaluation. So what we've done in the AIM system is created the time log that corresponds with that. So PLL applicants in the expanded pathway can note their hours. Once they submit those hours and they're validated by their supervisors and they reach 300 hours, an evaluation goes out to the supervising attorney. And once we get a positive determination, that person can actually be placed in the motion if they've satisfied the remaining requirements outside of the bar exam. And so I can report to this group now that we have one person that has actually met all of the requirements in the expanded pathway, and that will be appearing on the motion next week. And we have 7 others that are on that same track. So probably the week after, we'll have a total of approximately 8 people that will be licensed through the PLL program. Okay. Any questions about PLL? All right. With that, then, wanted to talk about the Blue Ribbon Commission. That's the next update. So the Supreme Court has selected its members for the Blue Ribbon Commission on the future of the bar exam. The court's in the process of reaching out to the selected members, and a formal announcement will be happening next week. Any questions related to the Blue Ribbon Commission?
Yes, Amy, when it starts to meet, will its meetings be noticed via the bar's agenda system?
Absolutely. So they will conform with Bagley-Keene. So they will be appearing on our website, and public attendance will be happening for those meetings. So they will be posted very similar to CPE meetings.
Thanks.
Mm-hmm.
Amy, any hints about who made the cut?
I have not received any information. So yeah, I'm just as anxious as the rest of you.
Well, who will? There's going to be members from CBE, right?
Yes, there is a CBE from the law school deans. There was a list of categories. I don't have them with me at the moment, but yes, representation from the CBE is definitely on the part of that plan.
It's a nail biter.
It's 2 from CBE.
So you and your twin. Okay, keep us posted. Well, I guess we'll just see a post. You'll send something out once.
Yes, we will send something out as soon as we hear from the court.
Okay, thanks, Amy.
Yes, and with that, now we also have Audrey on the June 2021 first-year law student exam.
Good morning, everyone. I have a very quick update. If you can believe it, we're getting ready to administer our 3rd remote first-year law students exam on June 22nd, 2021. We have 254 applications to date, and you'll remember that we were able to fold in all the testing conditions now into the application, so there's no extra external email that needs to go out for applicants to say they agree to the remote testing conditions. So that's a real positive. From those testing conditions documents, most of the applicants are fine testing remotely. 7 of them have said they wanted to come in with extenuating circumstances to the office, and 9 of them have said they wanted to handwrite. So that's just the numbers to date. And the final filing deadline for that application is May 17th. So the numbers will probably grow a little from 254. That's all for me.
Audrey, how many do you expect out of the taking at the office?
Well, for the baby bar, we've had maybe about 7 to 10 in each office. So yeah, very few.
Audrey, this is Kareem. Is there any indication that we'll be moving to a more in-person after the June 15th kind of removal of all the COVID-19 mandates?
So we're just operating under the Supreme Court order for now for the June baby bar and the July bar exam, and then we'll have to see. But I'm sure that will be taken into consideration.
Thank you.
All right, thanks, Audrey. Next, in terms of our updates, we have Tara Clark on bar exam strategies and stories program.
Morning, everyone. So we have 2 waves again this time. And so the final reminder email went out earlier this week, and the first sign up for the first wave of the program, excuse me, has ended, and those applicants will be receiving it in mid-May. And then we do also have the second wave available for those who are either repeaters or not able to sign up by the timely filing deadline. And so they would get the program in June. And then we have arranged, we're going to have Victor, the researcher, come and speak with you all again. He came and gave a presentation, I believe, a few years ago. And so we're shooting for the August meeting. So that's all I have.
Thanks, Tara. And my apologies. We also have an update on the differential item functioning. I know I mentioned that was the last thing in terms of our updates, but we have Michael Asiri who will be reporting back on the DIF program.
Yes, the DIF, or the differential item functioning group, met last week's Wednesday, so on April 14th. On the side, that's the day after my birthday, so yay. For this, it's the sensitivity and bias analysis training on just different types of wordage that can be used on Scantron, so the SS portion about just implicit bias in terms of gender, age, socioeconomic, which is huge for me, ethnic, cultural, racial, regional, religious, and occupational and political. The thing that they provided is a lot of examples of how specific wordage or like implied language can might have a result in different outcomes of different candidates from different backgrounds from being successful on that question or not. That's the nicest way to phrase that. It's one of those interesting things in which after taking that training, I actually am incorporating the types of more of the socioeconomic stuff in different avenues of my review on the bar exam committee. So it's one of those things in which I think it was highly beneficial. And I think should be something in which more members of CBE and probably the Blue Ribbon Commission should look into, just to understand how it's more, I mean, now in these days, we're not going to use charged language like the infamous SAT example of, I believe it's using lacrosse when it's a sport that not many people know of back in the 70s or 80s or whatever when the SAT was using it. But now in these days, I think it's more socioeconomic, definitely in terms of the use of technology. That might be something in which it might be very interesting to see how you can develop better ways of handling question types or assumptions that people should or should not have. But that's something in which it's an aside. I thought it was highly beneficial. The people who actually presented the training was Sarah Mastrani, and so I'm just trying to Chatali Badki. I apologize if I butchered those names. I know I despise when people butcher my last name, but yeah, overall, I think it was a extremely relevant training. It brought a lot of attention to, like I said, the use of language in a highly stressed environment that's time constrained. And one of the last things I'll note is it's interesting because the different type of Oh, I'm blanking on it. Sorry. All right. It was interesting because those examples of that the community that they were aware of federal compared to state law, specifically for California because it's California bar exam. I didn't see that as much of a huge issue because I think candidates should know California law more so since it's California, but they do know that people from out of state have more difficulties to grasp California concepts, but I think that's kind of implied. But I don't think there's any way to go around it, but it's rather interesting to try to devise ways of combining, I guess, the regional differences if you're out of state law school taking the California bar exam. But again, it's the California bar exam. But that's my overall review. Sorry for going a little bit longer than usual. I thought it was highly beneficial.
Thank you, Michael. So Esther, we are done with the staff update.
Thank you so much. We're going to move on to examinations, and that's with Jim Efting. Jim?
Yes.
Hi.
So for examinations, I'm sorry. I think we start with Lisa, don't we? And then I'm with the goals after that.
That item's been withdrawn. The first one's been withdrawn.
Okay. Sorry. So all we have is the goals, which is agenda item 0201. There are the first 3 goals have been completed. 4 goals, I guess, have been completed. We have some training from bar staff that's going to grading is going to take place, I guess, next month at the meeting. And then some ongoing goals with respect to access and inclusion and such. I don't have any particular comments on those. Does anybody else have any questions about the goals and objectives? If not, we can have a motion to approve the goals.
So moved.
David, thank you.
I will second that. This is Michael.
Oh, Michael,
Dr.
do we need a
Bolton?
roll call for that?
Yes. Dr. Bolton?
Yes.
Judge Brody?
Yes.
Dr. Kyle?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger? Ms. Heisinger?
Yes.
Judge Herman?
Yes.
Mr. Iseri? Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Pick?
Yes.
Mr. Rios?
Yes.
Judge Toriaba?
Yes.
Mr. Torres?
Yes.
Dr. Wilkinson?
Yes.
The motion passes.
Thank you. I think that's all we have for examinations
Thank
on
you.
open.
So the next one is operations and management with Alex Lawrence.
Thank you, Madam Chair. So here are our goals. And one thing that I'll just comment on from an ongoing standpoint is that we continue to look at opportunities for the production of the training videos. You know, it is targeted for the fall of 21, but given the current sort of situation that we're all in, that timeline may be extended a little bit, but again, there are no new goals. Tammy, if you want to comment on anything outside of that, I would also open up to the rest of the group if they have questions.
No, I do not have anything else to add to that. Thank you.
Are there any questions from the group? Okay, I'll turn it over to Madam Chair.
Thank you. Is there a motion to move to have the operation and management goals be approved?
So move. This is Kareem.
Second it, Madam Chair. It's, Torres.
Thank you. Roll call vote, please.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman, Mr. Iseri, Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Reyes,
Yes.
Judge Torioba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson.
Yes.
The motion passes.
Thank you. And Paula and Natalie will take over the educational standards.
Okay, the first item is the action on the proposed accredited law school rules upon their return from public comment and making a recommendation to the Board of Trustees. That is attachment 0, or rather O-400. As you may recall, we brought this back at our March meeting, and staff had some proposed amendments that they hadn't had time to share with us. So we put this over till today's meeting in order for us to be able to consider those staff proposals to modify the language, and also to allow time for it to be referred to the CS bars for their comment. So Dr. Cow and I did meet with staff. It was Donna and Natalie and council, and we talked over the amendments that were proposed. Ultimately, it was decided not to make all of them, but most of them were made, and what you have before you is the package that's recommended. Dr. Cow and I believe do recommend that its adoption and forwarding to the Board of Trustees for their approval. And we've also recommended that they make the rules take effect at the end of the year. I think, did we say December 31st, Natalie? I think we said January 1st or 2nd, correct?
January 1st, yes.
Okay. So then, and also that with the understanding that the schools will have up to 2 years to demonstrate full compliance with any provisions or requirements of the rules that have changed from the existing rules. CS bars, as was mentioned by Dean Gardina this morning in the public comment, agreed with all of the changes with one exception. And Natalie, could you put that particular paragraph up on the screen just so everyone can see?
So Ashley, I'd like you to show the that slide that also has the CS bars rationale line on there so they can see the reasoning why CS bars makes this recommendation as they do. Essentially, you're going to see an item about sanctions. There are several types of sanctions or notices that the committee might impose. You'll see in a moment when we do some inspection reports, the types of things that the committee normally would think about, asking for small changes that are reported in the annual reports, etc. And in the probation rule, there was a section that talked about probation, but said the committee may, among other sanctions it deems appropriate, place the law school on probation. Because the rule above mentioned something similar in clause 3 of 4.170, it's very interesting. CS bars found it redundant and confusing with the rule above, Staff put it in there just to make it clear that there were other options besides probation that the committee could use that were corrective, but more minor. And so it's very interesting that they just came down on the two sides of the issue. We checked with council and they considered it a close call. So the staff recommendation would stand to keep this clause in, but the CS BAR's recommendation would be to remove this one. And considering the enormity of the package of the rules and the number of things that were discussed, this is very close agreement, and we are very appreciative of the work of CS BAR's, Dr. Cow, Mr. Kramer, and Ms. Heisinger.
As your representative on CS BARS, I was present for the discussion, and I think another concern that I heard was that perhaps this was some way in the door to allow sanctions that weren't contemplated. For instance, fining, a monetary fine for a school for failure to comply with the rules. And as Natalie mentions, sanctions are mentioned in the rule previous to this, without any more clarity as to the scope or the limits of sanctions. So I don't see that this, frankly, I could go either way on this. I don't see that this adds much or takes away much. I guess it is just it's meant as a reminder that there are other sanctions that the committee could impose. And I'm going to go along with staff's recommendation, but I'll have to say I don't feel strongly one way or another on this particular point. With that, unless somebody has questions about this or any of the other specific changes that were made between our March version and this version, I don't propose to discuss them individually. They were described in the staff report. So are there any questions?
I have a question. Currently, are there other sanctions that are imposed in a situation like this?
Generally, those would be a notice or a posting or a request to make a change after an inspection that's reported in the annual report. I don't believe anything like a monetary fine has ever been imposed or is contemplated.
And are those other sanctions that you just mentioned somewhere else?
They are not specifically enumerated. One thought that was discussed during CS BARS was that in that prior rule 4.170, it might be appropriate to have an accompanying guideline to make clear the longstanding practice of the committee.
Okay, thank you.
Madam Chair, at this time.
Madam Chair, this is Judge Herman. Just a follow-up question on this. Again, does the removal of this prevent imposing other sanctions? Removal of this phrase, which is somewhat general.
I would call Ken Holloway, our counsel, just to weigh in on this. Originally, as contemplated without this, it wasn't intended to prevent the committee from doing what it normally does and would want to continue to do. In a final read through, it was thought this would make it more clear. But Ken, do you feel it is necessary?
I think, yeah, this is an issue that, as Paul and Natalie noted, I think folks could come down either way on, and I think everyone agrees that the intention is the same, whether it's removed or included. And staff initially included it to make sure that no one interprets the rule to limit the committee to probation, termination, or absolutely nothing else. But it appeared that CS BARS, wanted to make sure that the interpretation did not, create new options that hadn't been contemplated before. I hate to be imprecise, but it's really both sides really came down opposite in their interpretation. But there is agreement on what the intention is, and ultimately, council and staff are going to recommend the same process interpretation. Either way it comes down.
So Ken, what's the pushback in removing this? Why don't we just remove it and move forward? And you're
That's
legal.
that's a decision for, that's before CBE right now. And it's a question, it's a question of clarity, as I understand it, whether we're looking for clarity on the side of making sure in conjunction with the prior rule that it's well understood that probation is not the only option, versus the concern that CS Bars had, that essentially a new sanction would be created under this in some future interpretation. So again, there's sort of rationale on both sides, and it's up to the committee to decide.
Part of the reasoning was to be clear that supportive remedial action could be taken by the committee rather than proceeding to probation. And the intent was to hopefully make that clear through this clause.
Natalie, does that mean then if there is a motion to adopt the rules, that this would be a special portion saying that we also adopt to recommend removal of that particular phrase?
If you did not want to proceed with that phrase, then that's correct. We have an alternate motion that you could use. So the staff recommendation would be to include it, but we've also prepared an alternate motion that we can place up on the screen, and we'll show you both if you want to see them, or the one corresponding to the discussion.
I'm prepared to move to adopt the staff recommendation, again, that'd take effect on 1/1/22 with a 2-year compliance. Madam Chair.
Thank you. Is there a second?
I'll second that. This is Brody.
Thank you. Roll call vote, please.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
No.
Ms. Heisinger,
Yes.
Judge Herman,
Abstain.
Mr. Iseri,
Yes.
Mr. Kaplan,
Dane,
Mr. Kramer,
No.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
I have to abstain.
Judge Toriaba,
I also abstain.
Mr. Torres,
Yes.
Dr. Wilkinson,
No.
the motion passes.
Okay. The next item, get back to my notes, is action on the periodic inspection of Humphreys University Brevard School of Law. That's attachment O-401. This school was inspected in 2013, and at that time its accreditation was affirmed. Due to personnel turnover at the school, its next inspection was delayed beyond the normal 5-year period, and it occurred November of last year, 2020. Jim Efting and Dean Kevin Marshall of Laverne College of Law were part of the inspection team, which was led by our consultant, Heather Georgakis. The law school is part of Humphreys Stockton campus, and it had 89 part-time evening JD students in the fall of 2020. With the implementation of 10 mandatory and 3 additional recommendations, the inspection team recommends that we find that the school is in compliance with the accredited school standards and rules. The school's dean has communicated the school's agreement with the recommendations. I don't propose to discuss the details of the recommendations unless there are specific questions. And before I do that, let me just thank Jim. and Dean Marshall, and of course Heather Georgakis, whom I've had the pleasure of working with on another inspection, for their work and their report. So do we have any questions about any parts of the report or its recommendations? Okay, hearing none, is the proposed motion on the screen?
Paul, this is Kareem. So we're just going to speed up the inspection date.
No. The next inspection would be in the fall of 2025, which actually, is that a year earlier, Natalie, or were you
With
just
the
trying to get back on the 5-year cycle?
Yeah, so it's pinned from the date of the inspection. So the inspection took place in the fall of last year, 2020. And so it's adding 5 years to that.
Okay, it's normal then. Yeah, so no speed up, Kareem.
All right, no worries. I'll move to approve.
Jim Efting will second.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, thank you. The next inspection, our Vice Chair Dolores Heisinger was part of the team, so she was gracefully volunteered to present it.
Thank you. The Thomas Jefferson School of Law is one of the schools that we have that is transitioning from ABA accreditation to CalBAR's accreditation. This school is located in beautiful downtown San Diego. Looks like a really nice campus. In the mid-90s, Thomas Jefferson separated from Western State University College of Law, adopted the current name and has been operating as an ABA-approved law school. Thomas Jefferson went into this inspection visit as part of its transition to exclusive accreditation by the Committee of Bar Examiners. So, and the background goes like this. In November of 2018, after the ABA raised some concerns regarding the school's compliance with ABA standards, the school was had great foresight and decided to file a comprehensive self-study with us. And based on the strength of the self-study, this committee recognized the school's compliance with CalBAR's accreditation. As a condition of continued accreditation, the committee ordered that the law school undergo an inspection to confirm its compliance. And that's what this compliance visit did. So, and that took place in December of 2019. No, in December of 2019, the ABA actually did withdraw its accreditation. So Thomas Jefferson School of Law was left in a good position because it had filed with us and had begun the process for accreditation through CalBAR's. So since that time, the school has been involved in a teach out program for its ABA students and has enrolled its first accredited law school class in the fall of 2020 with 126 first year law students in the new California accredited program. Thomas Jefferson has a very diverse student body, and it is committed to building more diversity in its faculty. The dean, Dean Keller, has been actively involved in this the compliance measures for the new accreditation with CalBARS, and really has done an admirable job in the transition period from ABA accreditation to CalBAR accreditation. So there are 6 mandatory recommendations and 3 recommendations to enhance compliance. And those are part of the report. It's all yours, Paul.
Okay, does anyone have any questions or comments?
No questions. Just thank you for that work, Dolores. I know how intricate that process could be. I've been on a few, and I recommend to all the members and even new members to join an inspection. Natalie is very thorough, and did you work with Heather on this one too, Dolores?
I did. She's a delight. She does all the work.
That's what I was gonna say. You're so well equipped. You're just there to kind of learn and absorb and see how different programs run. So thank you for that. And then also thank you, Natalie, for always doing a good job, and Heather. And if there's no other comments, I'll make the motion to approve the inspection.
I'll second that. This is Vince.
So that's the motion recommended by staff, because there's more to it than that. There we go.
Do you want me to repeat all that?
No, but that's what you meant, right?
Yes. Ditto.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson.
Yes.
The motion passes.
Okay, thank you. The next item is action on an extension of the waiver for fixed facility accredited and unaccredited law schools, allowing them to continue to teach courses, classes online. Pretty self-explanatory. This would just be an extension of the existing authority that we've given them to teach online. And it would be till, I don't have the item up in front of me, I've got my notes, but till December 31st, is that correct, Natalie?
That's correct. And Ashley can put the motion up if you'd like.
Okay, I just, before we do, or put it up, but before we go to that, I just wanted to note that we received one public comment from a school that said that a December 31st deadline would be right in the middle of one of their teaching increments. I don't know if it was a quarter or a semester or what. And that was inconvenient for them because they would have to switch back to in-person classes in the middle of that increment. I talked to Natalie about this, and frankly, we couldn't come up with a flexible formula that could fit all the possible situations without causing confusion and uncertainty potentially for the various school students. That's because all the schools do not have a particular required schedule, and they can arrange it however they want. So we just didn't think it was possible to come up with some formula, and that a fixed certain date seems the better approach. And we note that those schools who feel they need extra time before returning to in-person classes can always file individual requests with appropriate accompanying justification for us to consider. So with that, if there are no questions or comments, we're ready for a motion.
Anyone going to make a motion?
I'll move it. So moved.
And I'll second Dolores. This is Robbie. Sorry, I was muted. I couldn't
Thank
get the words out.
That's a long one to read too.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Judge Toriabo,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson.
Yes.
The motion passes.
Okay, Esther, it seems a little early for a break, but I think the next item on the NPR was going to take a little while. So what is your preference?
We can take a break. Why don't we take a 10-minute break or so? So right now it says 10:13 on my clock. Why don't we reconvene at 10:25?
All right.
Thank you.
Yeah. It is now 1:25 and hopefully everyone is back and ready to resume the educational standards portion on the minimum cumulative bar examination passage rate. Paul, are you here with us? I don't see Paul Kramer's video on yet, and Natalie's here, so we'll just wait for Paul.
In the meantime, I'll take a moment to thank everyone for the questions and comments and thinking that you've done about this issue over the course of the month since the discussion started in March.
Is that David Torres's theme song? Yeah.
I will say that
when I was a wrestler.
I will say that it is not part of the pre-prepared NPR presentation.
I was going to say, Natalie, that's a little downbeat for.
While we wait for Paul, I know that Bethany has other obligations, so why don't we move on to moral character since it's really brief, and we will resume with Paul's portion afterwards.
Okay, thank you, Madam Chair. So for moral character, we are just reviewing and approving our goals. So if everyone has not had a chance to look at them, will you please take a gander? And for those of us that reviewed them in advance, does anyone have?
You're one step ahead, Ashley.
Wait, I'm sorry, what'd you say?
We moved on to moral character for the moment, Paul.
All right, this will be quick though, Paul.
Bethany, this is Robbie. I love your goals. As always, I'm going to move to approve them for 2021.
And I'll
Yeah, second that.
Yikes. I was going to say thank you for the educational stuff we've been receiving, Bethany. I truly appreciate all the learning we've been receiving throughout the meetings. I think Moral Character has done a good job of educating us on, equity and how we're moving forward. So thank you for that.
Yes, no, thank you. And thank you to David and to Tara, because they're the ones that organize all that. And I've also been enjoying our educational trainings as well. So in light of that, unless anyone else has any substantive bits, I will ask the chair if we can ask for a motion.
Was moved by, sorry, is Mr. Torres, did you second the motion?
I believe Rob moved.
Okay. So moved by Judge Brody and seconded by Mr. Torres. And Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Afting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer, Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
and Dr. Wilkinson.
Yes.
The motion passes.
Thank you. So I think that concludes moral character. Paul, we will go back to you on the pass rate. Paul? I will
text him as
Moving
well.
on.
I will try contacting him offline.
Esther, I'm texting him now.
Thank you.
Esther, I haven't heard from him just yet, so perhaps you may want to proceed and we can circle back.
Okay, that's fine, but we only have goals left and the pass rate, and then we'd be in closed session.
Should we move on with the goals?
Natalie, can you cover the goals or?
Sure. Sure, the Ed Standards goals, yes. Okay. So the last item on the agenda would be the Ed Standards goals. They have not changed since last month, but actually I do see Paul arriving. So maybe we could give him just a moment.
Okay. My computer just froze, except it didn't act like it was froze. So where are we and what am I doing?
We can start back at the pass rate, which you said will take a while, and you also have goals left.
Okay. Natalie was going to begin this with a PowerPoint.
Sure. Okay, so Ashley, I'll ask you to bring up the PowerPoint, and I'll just let you know, depending on the types of questions we get, we might be jumping around a little bit between sources to be responsive to the questions in the group. So as background, you'll recall that this discussion began in March in light of the creation of an alternative pathway to licensure as part of the PLP, which we heard about earlier. So let's move on to the next slide. We'll be talking about two things, the formula as it exists today, and then recommended amendments. You'll see a staff proposal and also some discussions and recommendations that came out of the conversation with CS BARS on Wednesday. Okay, next slide. Just as a quick reference, this is what the NPR calculation looks like today prior to any amendment. There's a 5-year reporting period for each calculation. It looks at the number of individuals who graduated during that reporting period and passed a bar exam during that period. You see an asterisk. Those that took that following February bar exam can also be included if they didn't have more than 10 opportunities to take the bar. And this is over the total number of individuals during that period from a particular school that took the bar. So if someone does not take the bar, they are not included in this calculation just by design. So since this was originally formulated, something new happened. The PLP was created, and we talked earlier about the two types of PLP options. The first one is for those who graduated between December 2019 and December 2020. Those individuals can practice under a provisional license, but they will eventually have to take a bar. There is also the PLP program with the alternative pathway to licensure, and folks that are in that program, we'll call them pathway PLLs. Those may be able to avoid taking another bar exam in the future. And so let's go to the next slide, and we'll talk about the overall theory behind the staff proposal about the changes that, that should be made as a result. So once the Pathway PLL program was created, the Supreme Court clarified 6060G, a Business and Professions Code, and that is the item that says that as part of the elements for licensure, the candidate must have passed the general bar examination given by the examining committee. That can be achieved by earning the cut score associated with the exam you're taking outright. But the court amended the court rule to say that there is also another way. For those that achieved a 1390 between the July 2015 exam and the February 2020, who also complete the other requirements of the pathway, will also be deemed to have satisfied this requirement of 6060G. So what we're suggesting is that you update the calculation to include not only those who passed a general bar exam outright, but also the others that can now meet this requirement through entering and fully completing the pathway. Okay, does anybody have any questions about that theory so far? Okay, let's go to the next slide and we'll talk a little bit about the difference between the staff proposal and the CS bars proposal. And there were a couple of elements of the CS bars proposal in layers, and I'll try to talk about them here one at a time. So they are aware of the changes that we talked about, but they have a couple of other suggestions. From the staff point of view, the NPR is in part a regulatory measure. It measures the number of individuals that the school could prepare for licensure under the conditions that existed at the time. From the dean's proposals and point of view, and you heard this in the public comment, they feel differently. They would like to include in the denominator, in addition, not only those who enter the PLP program, but also those who earned a qualifying score to enter the program, that 1390 to 1439 on one of those prior exams. The staff proposal does not proceed in this manner for a couple of reasons. First of all, it doesn't comport with Supreme Court guidance. Second of all, it doesn't comport with what the ABA is doing. They're not recognizing these either, though the committee is not bound by that. And third, these individuals, in placing them in the denominator, we could actually, in the numerator, we could create confusion because all of them still remain eligible to enter the pathway, which could create double counting, or they remain eligible to take a bar exam and either pass or fail. And putting them here in this way would deprive the committee of the opportunity to categorize them based on their actual results. So I wonder if, Paul, if you would like to take a moment just perhaps to discuss the 1390 issue at this moment, or shall I proceed?
Sure. In public comments, Dean Winnick suggested that the Supreme Court had basically retroactively applied the cut score, or is saying that we should do that for purposes of the NPR. But I disagree with his assessment. In my view, what the court has done, it certainly has not made 1390 retroactive. It has carefully avoided calling those who score 1390 bar passers. And we can see that in their recent amendment to the rules for the pathway program, where they characterize somebody who goes all the way through the program, which means you had a 1390 and you worked your hours, your supervisor gave you a positive recommendation, you met the moral character and the other requirements, the MPRE. It said that after you've done all that, you've come what we call successfully completing the pathway, that then in effect they're waiving the requirement that you have passed a bar exam, or they're saying that you have done via a different way, you have met that requirement. But they're so careful not to call them bar passers. I don't fully understand why they're doing that, but it is clear to me that they are doing that. And I think there's one difference between, and at the CS Bars meeting, the argument was made that it was important to have our number be comparable to the ABA's numbers to allow potential law students to compare and contrast law schools and use that information in deciding where they might want to get their legal education. But they really are apples and oranges in many ways. The ABA only looks at 2 years. The ABA has a much higher standard of 75% passage. Even as we've had some trouble getting, unless things have changed since yesterday, getting an actual written expression of the ABA's advice to schools
Paul,
to
I do
use
have one that I can show.
Oh, okay. But as we understand the ABA's approach, it's a little different than the law schools characterized it. I think the one place it differs from our staff recommended approach is, are you putting it on the screen or?
Yes, but before we go there, can I stay with that slide for just a second? I want to emphasize a particular point. If we look at that second element in the numerator, that plus, including those earning 1390 to 1439 through the February 2020 exam, I want to be clear that the ABA is not doing that. And also the Supreme Court guidance did not suggest that either. And I think the timing is instructive. When the court adjusted the cut score effective October, they issued a letter saying that the cut score adjustment was not retroactive. After the creation of the alternative pathway, again, law school administrators approached the Supreme Court and said, should this be applied retroactively? Should these be included? At that same time, the ABA issued its guidance saying no, it should not. And the court issued its court rule clarifying that no, it was not. So to add in this element after the plus would be to depart from the ABA and the court, which made its decision after considering comment from deans and the ABA.
Okay, and then,
but let's go to the ABA comment if you're ready, Paul.
oh, sure.
So the ABA comment that is being placed up is the actual comment that was provided to the schools when the ABA was originally considering how their ultimate pass rate might be adjusted to affect not only California's changes, but also diploma privilege that's seen some other places in the country. The original guidance addressed only diploma privilege. And so subsequent to that in February, an additional communication was sent out, and this is that actual communication as it was sent out in February. And then Paul, would you like me to take them through it?
Sure.
Okay, so it talks about two things. The first one talks about those that are PLLs that are practicing under the grad date version of the PLL. So that's the original part of the program, graduating between December 19 and December 2020 under a provisional license, but having to take a bar exam. And so the ABA proposes to treat those individuals the way that they're proposed in the staff proposal. And we heard no objection from CS bars, which is if they have taken no bar exams, they just went straight into the provisional licensing program, they'll be excluded as a non-taker consistent with practice. Once they take bar exams, they will be classified according to their pass or fail result. And so I believe everyone is in accord as to that. The second one is to look at the PLL portion for those that qualified based on a prior bar score to enter the program. And for that, the ABA will begin to count those individuals in the in the numerator as soon as they enter the program. Now, why will they do that? And why is that different than a result that might be appropriate for California? The reason is that when the ABA looks at their pass rate, it's just for 2 years, and schools report for a particular class. To give you a real example, this year, the class of 2018 was the class that was reported, and schools were required to report it sometime around the end of March. So the ABA needs a sooner decision in a shorter time. The PLL program with the Pathway to Licensure had just launched less than a month before. It was almost mathematically impossible for someone to have completed it, and the ABA needed interim decisions. Compare in California with a 5-year time frame, and we have other slides that will take you through this more slowly if you'd like. With a 5-year program, there will be the opportunity for schools, for the participants to get all the way through the program. So they must apply by May. They, as you heard from Amy, are already starting to emerge from the program, successfully completing the results, and they must complete them by June of next year. So in summary, the ABA would count the individuals as, I guess, passers in the numerator upon entry, but we suggest counting them upon exit to be consistent with Supreme Court guidance and making an adjustment to the denominator, which we'll talk about in a moment.
And that's not just exit, but successful exit.
Correct.
All
Because
right, I have to jump in here because this is getting very technical. Okay. I hopefully we could just break this down and make it more consumable for someone like me. So my understanding is we have multiple options. Right now, there's an option to move forward. Oh wait, we're not at the motion yet, so I'll wait for that later. But
So
to break down this ABA.
While you're doing your question, I'd like to ask Ashley to move back to the CS bars proposal so that we can do a little pointing during the question.
Awesome, thank you. This is I tried to do like mathematical equations, and math is not my strong suit. So I was hoping to rely on you and Paul to help give me better clarity. So my understanding, so are we looking to mirror ABA, or are we looking to do something different?
So I'm going to ask Ashley is in the process of switching back to the PowerPoint slide. What I propose is that we follow the Supreme Court guidance. The Supreme Court has indicated that a person who satisfies the 6060G is not only a person who gets the score outright, but also a person who completes the pathway. And so I would encourage you to follow the Supreme Court guidance.
Yeah. We lost
actually,
Natalie. Just
ahead,
real
David.
quick question. The designation that we're talking about, whether passer or non-pass, is this basically for statistical purposes as it relates to the law schools? In other words, law schools would get information indicating a bar pass rate. A number of them were non-passers or takers, but ultimately passed as a result of the PLL.
Yes, so we use that as regulators, and definitely the public and students would look at it as well.
Well, because what I'm asking, I guess, is because it is, I agree with Karim, it is a little bit complicated. We're not basically going to set these folks who pass through the provisional licensing. We're not basically doing something different to their license, indicating that they didn't pass the bar, they went and through some other route. We're not going to create a different class, are we?
No, we're not. But we're not doing that at all. And there won't be any way, once they are licensed, to tell when someone looks them up on an attorney search. Really, what we're trying to do is keep the stats consistent in California. And so by recognizing those that pass a bar exam, and also recognizing those that complete a pathway, which is going to match what they can find in attorney search, that creates a clean and consistent decision and clean and consistent data in California. If we add those quote, I'm not sure what to call them, the folks that earned a 1390 between July 2015 and February 2020, the problem with that is that will not match bar statistics, that will not match published pass fail lists, that will not match what the ABA is doing, and that will not match the option of these individuals to license unless they enter the PLP program or pass another bar exam. And so this is really what the schools are saying is sort of, this calculation is what are my chances I'll get a 1390 in the future, because that's the cut score now. But really it shows what happened at the time when the students were, or now the graduates were participating. And I just, I'm gonna just double check. Ashley, do you want to turn control over to me to put the PowerPoint on, or will you be able to do that?
Sorry, is it still not showing? It's not showing the PowerPoint? Sorry
No,
about that.
it's showing the
Yeah.
ABA.
I'm so sorry about that. Here we go. It should be showing the PowerPoint now.
Okay, please
So
go
if I
to
could
the
clarify,
next one.
oh, I'm sorry.
Yeah, there we go.
Sorry, Natalie. So to clarify, that statistic could potentially support a school that's on the bubble, if we move with option 2. Is that accurate to say?
Yes.
And do we know of any schools that would benefit from that?
We need to be careful about which option 2 we're talking about.
Okay, that's where I'm trying to. Sorry, my notes are all over the place, but that's where I'm trying to be.
Any change to the rule that's on the table would slightly increase the percentage for a school. There's no proposal that I'm aware of that would actually reduce somebody's NPR.
Yeah, that's correct. And I wonder if we could break it down a little bit. So I just put out there the thought that everyone seems comfortable, at least so far, that if someone does meet all of the requirements of the pathway and becomes licensed, that there shouldn't be any problem with placing them in the denominator. Would there be general consensus around that thought? We'll move on to some other thoughts next.
Well, you mean the numerator and the denominator?
Correct.
Treating them in the same way as a bar passer is counted.
Yeah. Mm-hmm.
So there's no difference then between, except for statistical purpose, between the bar passer and the individual who ultimately passed.
Right.
Yeah,
yes, that's correct.
Okay.
So this isn't
is that
about
the ABA
categorizing people.
guideline? Is that the ABA guideline?
Well, we'll get to a little quibble of a point as to whether to include them at the start of the pathway or the end. I would say let's defer that conversation for a moment. But are we all in agreement, or would the committee be in agreement that these should be included in the numerator?
Yes. It's the.
Okay. So we'll get onto the detail. We'll circle back to this in a bit. But before we do, let's take a moment and focus on an addition that would make a major change to the NPR, but would go against Supreme Court guidance, ABA statistics, and be a challenge to report with consistency in California, which is to take those individuals who earned a 1390 to 1439 from July 2015 through February, should they also be placed in the denominator I'm sorry, in the numerator against the Supreme Court guidance, against the ABA practice, but in support of the CS BAR's recommendation. This would improve the pass rates of the schools by placing those individuals here in this numerator, but it would place individuals in the numerator that were not adjudged to have passed the bar by the court and who are frankly still eligible to take the bar or enter the pathway. And so it doesn't seem appropriate to have a final placement for them. And I'm going to turn it back to Kareem because I feel like I cut his question off a little bit, but does that make sense?
It does. So we've agreed that they'll be counted once they fully completed the program, but this proposal will extract, it'll keep the current. See, what's hard for me, and this is my train of thought, and I know you'll be able to interpret it better, is that if this individual received 1390, then ultimately they quote unquote passed the test based on Supreme Court's guidance. But what the proposal is from the Supreme Court guidance, I assume, is that it's not retroactive, and so they're not fully completed until they graduate, meeting all the other criteria. Is that kind of, am I following the same steps?
Yes, so basically one of the elements for placing them in the denominator in contradiction and the numerator in contradiction to the CS BAR's proposal is that they must enter the PLP program and then pursue the requirements of the PLP program. Until they do that, they should not be considered a passer per the guidance of the Supreme Court and the adjustment of the court rule. Are you comfortable, is the committee comfortable with that? And Paul, maybe you could give your perspective on these individuals that have
And just let me,
not to enter the pathway.
if I could qualify,
I think
just
we're getting
clarify
ahead
that.
of your, go ahead, David.
Yeah, and I'm just curious if you could just clarify that, because if you fall within the parameters of not passing but eligible to pursue PLL, that's not a requirement. You could just basically opt to retake the exam and not engage in the PLL, correct?
Right, and so really this placing them in this numerator is premature. These individuals have two choices: take the bar exam again or pursue the pathway. And after taking one of those actions, that's when they should be added to the numerator. So that's why this section after the plus is not recommended in the staff proposal.
Okay, all right.
You have more slides, right, Natalie?
Yeah, I do. Okay.
I'm
so
sorry,
let's-
Natalie. No, okay.
No problem. Let's keep going. So let's think about those that enter the pathway for a moment, and let's go forward in the slides. Okay, so we talked a little bit about for those individuals who got the qualifying score but don't enter the PLL, then CS BARs would recognize them. The court would say that you must complete the pathway. The ABA would say you must at least enter the pathway. We've got a shorter runway, just 2 years. Okay, let's go to the next slide. So just in summary, if we think about the different things we've talked about so far, at the last meeting, everyone determined that the October 2020 bar exam that would have been held in July should be included as part of the calculation. It seems like everyone is in agreement that the graduation date PLLs should be classified in the NPR according to the current calculation and in accord with the ABA. So you don't take the exam, you don't go into the calculation. You do take the exam, you go based on your results. But now here's where the divergence is. The CS BARs would ultimately ask for the larger step of anyone who had earned a 1390 in that retro period when the exam score is not applied retro to be included in the numerator. If not, then they would make a small change to the way that those in the PLL program are recognized. Rather than recognizing them upon completing the requirements, recognize them upon entry. This could be somewhat of a distinction without a difference because it looks like people will move through quickly. Essentially, the CS BAR's proposal would enlarge the number that could be in the numerator by adding people that have not yet satisfied the requirements of 606G.
Yeah, and so is this a good opportunity to have discussion, or what are our plans with the discussion right now?
Yeah, I think well, please go ahead, Paul.
I'm not sure we've fully explained what the staff recommendation is, or there may be some confusion, Natalie, because you were just talking about the CS BARS proposal. But what the staff recommendation is, and which I support, is that for those who are in the PLL pathway the pathway portion, or who are in the pathway, we temporarily take them out of the denominator until they exit the pathway in one of two ways. They exit it successfully, meaning they've completed all the other requirements and they are able to be sworn into the bar. Or in that case, then we put them back in the denominator, and at the same time we put them back in the numerator, because they have done something that is comparable to having passed the bar. If they exit unsuccessfully, let's say they have moral character issues that cannot be resolved, or they just drop out and quit for whatever reason, then they go back in the denominator and they do not go in the numerator because they haven't finished and achieved the equivalent of passing the bar. That's the proposal, right, Natalie?
Yeah, and I'll ask Ashley to go forward to the next slide that says recommended amendments. I think we have to go forward a couple. No, actually, you'll need to come back. Let's stay on the slide we were on. Okay.
So that's the proposal. What the schools want to do is they want to count them as having completed the program as soon as the pathway, as soon as they enter it. And that is the ABA's approach. But as Natalie has explained, they have a tighter deadline for fixing the status of a student or graduate for purposes of their calculation, which we don't face.
Yeah, so would it be helpful to run through an example of how the staff proposal would work?
I think so.
Okay, let's go forward in the slides. Let's go one more. Okay, so for those that are in the alternative pathway, as Paul was talking about, imagine it this way. Upon entering the pathway, they will have the opportunity to pursue licensure if they complete all the requirements. So think of it almost as a pending result. Okay, so during that time of the pending result, as a concession to the schools, we propose to remove them from the denominator, almost treat them as a non-taker, because their results are pending while they pursue the pathway. Okay. Now let's go to the next slide. So how would that look? So if we're going to use this school as it's not a real school, but a hypothetical school for all of our examples, if 100 students graduated from law school during the reporting period and 50 had passed outright during that reporting period, but 4 earned that qualifying score that we talked about, a 1390 to 1439 prior to October, and they made several choices. 3 of those 4 enter the provisional licensing program, 1 does not. So what will that do to the MPR? For this school, if the MPR were to be reported today, they have 100 students who graduated during the reporting period and took a bar exam. And so they would normally have 100 as their denominator. But in fact, there are 3 who are participating in the pathway would be removed from the denominator while they were pursuing it. This would be a little bit of an advantage to the school. What it would recognize is that once one of these individuals enters the pathway, they will not have the incentive to take another bar exam. They will be focusing all of their energy on completing the alternative requirements instead. So perhaps, absent that pathway, they might have taken and passed a bar exam. We recognize that and propose a concession to the school. So 50 have already passed, and the 3 that are working toward the requirements are removed from the denominator. Okay, let's go to the next. Any questions here before we go to the next piece?
So in this example, this school would have a 50% NPR, or no? It's
Slightly,
50 divided by 97, right?
slightly over 50%.
Yeah.
Yeah, divided by
Okay.
97. I won't make you do math.
Yeah.
Okay.
Please
Right.
don't. Please don't.
Okay, I promise. Next slide. Okay, now after an individual completes the full pathway, then they would be added back to the numerator and the denominator. So let's go to the next slide and we'll see an example of that. Okay, so we have our same school, 100 students, same passers, 50 passers, same 4 entering the pathway PLP. You remember 3 entered. Well, now one of them has completed. What if the NPR is being reported today? Well, that one completer goes into the numerator and denominator. So it becomes 51 out of 98 becomes their NPR. I certainly won't ask Kareem to do that math. Okay, next
A
slide.
1% increase is what I found.
Right, but you've also got another passer in the sense that they completed the pathway. And I think I might have heard a question. Okay, next slide. Okay, what happens if they exit the pathway without completing it? We think this will be a small number, but there could be individuals that do that. If that's the case, if they exit the pathway without successfully completing, or the program just simply ends before they can complete, then they will go back into the typical pool of those being reported, and they'll be placed based on their bar exam results. And all of these individuals have had unsuccessful results in the past. They might take bar exams in the future and pass. So if we go to our example on the next slide, same school, same stats, but now they have someone who exited the pathway. Okay, and so they're just simply added back into the denominator. 50 over 97 was our original number, 50 over 98 now. Next slide. So in summary, if all of those actions happened, just to make it clear as to what would happen to each individual, 3 enter the PLP program with an alternative pathway to licensure, 1 completes, 1 exits, and 1 is still in there and the program hasn't completed, then the first one who completes will go into the numerator and denominator as so-called passer. The second one who exits will go into the denominator. They exited without completing. The one pursuing will still just be withheld from the calculation. So that's a summary of how it would be handled. Just to, for purposes of comparison, what is the ABA doing? It's a little bit different. They are accepting the student at the graduate at the start, but they are not making any adjustment in the denominator. Here, we propose this instead of what the ABA is doing because it better reflects what the court says is satisfaction of 6060G. And it also better reflects that individuals in this pathway could have several outcomes. They could complete the pathway successfully or not, and then they'll be classed according to what ultimately happens to them. So that's a little bit of what the proposal is, and I'll turn it back to Paul for discussion or perhaps entertainment of a proposal.
Okay. Yeah, as I said, I support the staff proposal, and it's reflected in amendments to the guideline that are part of the materials. none of these changes, the difference between the various approaches is results in very minor changes to a school's NPR, unless they have, I suppose, the majority of their graduates were 1390s, and I don't think that's the case for anyone. And any of the staff proposed change, I believe, inflates or increases the NPR for the least amount. And it's also important to note this is basically just going to apply during 2021 as it's written. When we get to 2022, at least as currently formulated, the PLL program and the pathway will have ended in the 1st of June. And so any students who, even if they were excluded from the denominator this year because of the proposed change, would be added back to the denominator then and of course to the numerator if they passed the bar exam or successfully made it through the pathway during that time. But if they haven't, the schools are going to be back dealing with a student who has failed to pass the bar exam or the equivalent pathway, and will be counted against them, if you will, or it will reduce their NPR because they'll just be in the denominator.
I have a question, either to Paul or Natalie. I have to take a couple steps back. I'm trying to understand this. Is this proposal, the one you're supporting, Paul, it's in some conflict with the ABA, but is it something so serious that it skews any numbers? It seems to me that just listening to you that it doesn't really matter that much. I'm having a hard time understanding that.
I suppose somebody who's hovering around 40, well, somebody who is at 40, which is right on the razor's edge, they'll be okay with this proposal because their number might go up a little bit. Somebody who's at 39, maybe it matters to them because they want to get above 40. But it is a minor difference. It's a timing difference. If you assume that most everyone who enters the pathway is going to be able to complete it, then it's a question of at what point you can count them. The ABA would count them once they qualify for the program and start the pathway. We would count them only after they have completed the program, and that's a matter of months, maybe. It depends on the person. I suspect the 300 hours may not be the limiting factor for timing, but just if somebody doesn't have an active moral character application until they enter the pathway program, it may be the delay in the moral character process that is the limiting factor.
Let me, I've got a question about what you just said. With respect to the PLL, first of all, 2 questions. One, my assumption would be if a person works a 40-hour week, that person's going to complete approximately 160 hours, which means it'll probably take at least 2 months to complete. I mean, my belief would be that if a person really wanted to get this thing done, they would do it as quickly as possible, or at least that would be the smartest thing to do. Secondly, that's 2 months, but what do we have right now? Do we have any statistics showing what it's taking, or is it too early in the game?
Yeah, well, we're pretty early in the game. Amy mentioned that one person has completed, 2 are about to complete. Overall, it seems that so far, though there is still time for more to apply, there might be about 60. And as far as the difference between the ABA proposal, it's actually quite close because while the ABA accepts at the start and the CS BAR's proposal the staff proposal accepts at the finish, it does adjust the denominator. So I think the results will be close. And we think that many will have the time to complete by the reporting deadline of July 1st. So
What-
quite a lot could be. And part of the staff proposal is to accept anyone who completes through July 1st. So if they applied right at the beginning, David, to your point, they will have had March, April, May, June, 16 weeks to complete those 300 hours.
And the other question is, what's the ABA's rationale behind taking the percentage up front? Is that because, and I hate to say this word, but is that because it's pretty much a given that if you have that person that needs to just complete the 300 hours, that person, for the most part, is going to do it?
Maybe,
there has to be. Yeah.
Maybe, but it's also logistical. Their timing to report is in March. And so it doesn't give as much time for them to complete the pathway. So given that they didn't have time to complete and they probably will complete, they went with that certainty and fairness to that class of 2018, 2019.
I think it's safe to say that this is some difficult concepts to wrap your mind around, and it's takes a while. I've seen the staff and the subcommittee spend many long hours trying to come up with a recommendation that I think is does several things. It addresses the letter of the law. It addresses what the Supreme Court has mandated. And I think it has come up with a plan that does not penalize anyone. So I support Paul's recommendations to accept the staff recommendations.
Yeah, really quickly, I have a comment though. I think there's more discussion needs to be had on this because this is very, very important. And one of the things I want to be careful about is that the ABA is moving in a direction, and Paul, you brought up some great points about the ABA expectations. But I think in my research, the average cut score is 1350, and New York is at 1330. So to put us into the same category as ABA schools and seeing our CALs at that level, I think prevents some sort of alignment with the ABA proposal. But my approach on this is more about our not our mandate, but kind of our I think it's been 2-3 years we've been pushing into this lane of diversity, equity, and inclusion. And so the State Bar actually provided a report where if we would have moved the score from 1440 to 1390, we would have seen African Americans increase by 6.65%, Latinos by 5.01%, and people from Asian backgrounds at 4.69%. And so for me, with those type of swings, I think what it creates, and because we just approved new Cal guidelines, I think it promotes a lot of equity when it comes down to who's going to ultimately benefit from this. And I think for the most part, we should go in the ABA route, considering even David's comments about if this is done within 2-3 months, and that's being hypothetical because I live in a community where you have a family, you go to school, and we understand that CALs are opportunity schools where people typically are moving into a second or third career, and also doing a complete career change. So I think the ABA alignment actually puts us on the same path. And while I understand the Supreme Court gave guidance, we also understand our duty as a committee of bar examiners is to operate on behalf of the court and make recommendations to the Board of Trustees. And so I think we have an opportunity to lead and give our interpretation of their guidance, and really develop an alternative that shows that we're moving in this direction of acknowledging the diversity, equity, inclusion. And it could be small percentages, but I think for the most part, it acknowledges that a person who's 1390 has dignity in their passage, and has a pathway. And we talked about this previously, that the way they arrive to the bar is the way they arrive to the bar. And I think that should be noted in the NPR, considering that's our main policy point when it comes to accreditation and inspections.
So Kareem, this is Natalie. A couple of things just to be clear. That 1390 element is not part of the ABA proposal, so you would not be going with the ABA. And we've received a comment from CS Bars, and Ken, would it be possible to take a brief public comment from the chair of CS Bars to confirm? They're indicating that they want to clarify what the CS Bars proposal was.
Yeah, I think that's permissible.
Is that
Yeah, I think
Esther?
my 1390 was in connection to the Supreme Court moving the cut score to that, and that being the criteria to enter the PLL program.
But right, so only upon entry would the ABA recognize it. And I don't want to speak for CS Bars, but Madam Chair, would it be possible to recognize the chair of CS Bars, Jackie Gardina, for a brief public comment?
Sure, that's fine.
Thank you. So Kim, if you could recognize Jackie Gardina, who is one of the attendees, just to confirm the CS Bars understanding of those who have not entered the PLL.
Evan, can you please give Dean Gardina access?
Thank you. This is Jackie Gardina, Chair of CS Bars. I just wanted to clarify what the CS Bars recommendation is to CBE. There seemed to be a little bit of confusion based on what the CAL's 4 options were versus the CS Bars recommendation that was voted on Wednesday. I believe Paul accurately represented it in his comments, but on the slide there was some confusion. And that is that we are recommending the ABA approach, or the ABA option, which was accurately represented here. And so I wanted to be clear about what CS Bars had recommended via a vote versus some of the other options that were being floated. So thank you for that opportunity to clarify.
Thank you. I appreciate the opportunity to hear directly from you as the chair of CS Bars. Thank you, Chair Gardina.
Yeah, I have another comment. I'm pretty sensitive to what Kareem was talking about in terms of the diversity and inclusion, equity. And even though this is sort of a short range kind of situation, because it's going to be over in several months, those populations are hit the hardest. So again, I just want to figure out if we're not in alignment with the ABA guidance, even though it's potentially small numbers. The people who are affected the most potentially are the folks we're talking about in terms of diversity and inclusion and equity. So I'm just trying to, I'll kind of re-ask my original question. Is the conflict between the two major that it really affects these populations more than the mainstream?
I don't believe that's the case. I mean, I think there are 2 elements. The first thing is the reporting will not change the status of the individuals, so it will neither advantage nor disadvantage them. Okay. And then because the ABA reports at the reports upon entry, but the staff proposal would report upon exit, but does make an adjustment to the denominator, the overall report and score of the school would not be largely affected, but it would conform to the Supreme Court's guidance. So this California statistics would be more harmonized without largely changing the NPR or any individual status.
Okay, yeah. I think that helps.
Yeah, this is simply about our measuring performance of the schools, but it's not going to get anybody into the bar as a practicing lawyer or remove anyone.
Yeah, my concern was, does it make the numbers look exclusionary in any way? And it doesn't, at least in my understanding, it doesn't seem to do that.
Right, and part of the reason for that is that you're making the adjustment to the numerator and the denominator, so they are functionally nearly equivalent, but they operate consonant with the Supreme Court guidance.
Can I jump in there also? To respond specifically to Kareem, I understand your concern, Kareem. I share your concerns, but what we're talking about really doesn't have anything to do with affecting the diversity or penalizing any community. The programs, the PLL program and the extension pathway to licensure were the programs that have assisted potentially the communities that we're concerned about, minority communities. So we're simply talking here about how the schools, how the law schools can, where they can place these people as completers or not completers, or test takers or not test takers. That's simply a statistical thing. It has really no impact whatsoever on who's affected from any kind of minority community.
Yes, Dolores, thank you for your comment. And I would counter that it has everything to do with those communities for the simple fact that we just adopted new California law school accreditation guidelines that is asking for these schools to provide demographics on how they're supporting diversity, equity, and inclusion. And so when it comes down to using a statistic that is our policy point to where we identify certain passage or non-passage, it does ultimately come down to, and I just provided the percentages of students that would benefit and schools that would benefit that maybe are more inclined to support students from diverse backgrounds inside of communities, is where I believe and my perspective sees that if we align with the ABA and support the CS BAR's option, I think it gives credit. It gives a bit of like a dignity to those students that did pass, and that's just my respectful opinion, because I see sometimes we have systems in place that sometimes create barriers, and so I think that's just looking at it as a statistic is simplification. Where from my perspective, I look at it from my lens of my city, where somebody who has a 1390 enters the PLL might as well, it is a passage and should be included in the numerator. And that's just my my opinion.
I would actually agree with Kareem on that as well.
And my community doesn't, we don't have any law schools within a 45-mile radius. So for those for those opportunity schools that are located in areas that don't have access, I think this creates some element of support to our CALs on the front lines doing this hard work. Because in my inspections and in my time here at the bar, I've seen the type of student that has entered these schools, and I give them all the credibility and all the support because they're entering second, third careers. Some of them are older, some of them are, have families, and so at the end of the day, what it means is our CALs are able to showcase that diverse element to their schools, and which we support as a committee, and ultimately as a state of California. I think that's something, the direction we're moving in. And so I just would ask that, I get support to move in that direction, to respect it, that the CS BARs did make a request, and I think we could build a stronger partnership if we go that direction.
I'm sorry, Kareem, I just don't see the connection between the statistical measure and the goals that you're advocating.
I understand, Paul, and I always appreciate your candor and your honesty. I just think for me as a person of color, that's how I view it, because I come in a community where I don't have access and I don't have those elements. So I look at these things differently, and I just present my opinions on those because I could see how it has unintended consequences. And that's, as a public member, I see that as my role to elevate some of those concerns, to kind of elevate, our own consciousness as a committee about how policy has unintended consequences. Even when we reduce it to just a statistic, it's more than a statistic. And I've talked about this before, about when the people came to give us an analysis about statistical dust. One person, two people could change our entire landscape. Because of a Cal school, we had the first undocumented attorney in the state of California that changed policy. And so we know these CALs have ability to create ground sweeping reforms. And so when it comes down to discussing statistic, that's how I view it. And the other part of the discussion is how I extract it and how it could impact my community in this region of the Inland Empire that doesn't have these type of access that other communities have.
And so
Well,
I think it might be an appropriate time to ask Ken to help refresh us as to 6060G and what the MPR is measuring.
Yeah, absolutely. And this has all been teed up before, but I think now I just wanted to kick it to me for a reminder from council. But the issue that's come up several times is alignment with the Supreme Court directive, the Supreme Court, not directive, but the Supreme Court language that they used to amend the PLL pathway program. And again, with the way the Supreme Court framed that is that initially the Supreme Court declined to make a retroactive pass score when they cut the pass score. And then in revising the program, the Supreme Court stated that, I don't want to get this wrong, that someone who completes the pathway is going to be deemed to have satisfied the requirement of the statute and essentially be deemed to have passed the bar or deemed to have done something equivalent to passing the bar. And that's been one of the sort of the key issues that Natalie's been teeing up here. Essentially, there are 3 steps along the road to somebody who's going to get licensure through the pathway. There is the 1390 or higher score that they got. There is entering the pathway, and there's completing the pathway. And really, hopefully that's a little more clear statement of what's before the committee. That there are 3 steps along the path for that person. The question for the committee is how to count at those 3 steps. It sounds like folks in CS bars, even with that clarification from Dean Gardina, are not advocating for counting somebody who just got a 1390 as a deemed passer. The question is the second step, the third step, entering the pathway, completing the pathway. And what Natalie the reason I think Natalie kicked over to me is to just talk about the Supreme Court in terms of defining who is a deemed passer, looked only to the third and final step there, completing the entire pathway. And so while the ABA, as Natalie discussed, it sounds like for expediency and for the reasons that they have in their reporting timeline, wanted the clarity of the second you're in the pathway, we're just going to conclude that you finished it, essentially. The Supreme Court for us was pretty clear about, to be deemed a passer, you need to reach the point where you have completed everything in the pathway. And so again, the other piece of it is the MPR is a calculation of bar passage, which was very straightforward concept until this year. And so, while the CBE gets to determine how this calculation of MPR is made, what we have from the court is their pretty clear interpretation of what is a passer and a non-passer in this kind of squishy pathway program, or what should be deemed so. So hopefully that clarified a little bit and answered what Natalie was hoping I could.
Let me ask this question then. So let's assume that you've got a law school that ends up below the MPR, and they're obviously can be sanctioned by our group, but they've got several individuals that are in the pathway. So are we going to give these individuals, these schools, leeway to allow them to complete this, or are they going to be admonished, or what steps are we going to take at that point in time?
Well, the proposal does do that because it takes those people who are in the pathway out of the denominator until they resolve their status in the pathway. So if they complete the pathway successfully, then they'll be put back in the denominator, but they'll also be put in the numerator. So they will be one person with 100% averaged against all the other graduates. So it's not that much different than the ABA proposal. The ABA would put one in the top, add one to the top and one to the bottom of the equation. What we do is take one away from the bottom while they are in the pathway. And that has the effect of raising their NPR slightly. Because it'll be, in Natalie's example, it'll be 50 over 99 versus 50 over 100. And if they successfully complete it, it'll go back to 51 over 100. And if they don't complete it, it'll go back to 50 over 100.
Thank you, Paul.
Yeah, and
Do we
also,
have any stats on?
Wait, Paul's example is not correct, I think. Wouldn't that be if you remove one from the denominator, you also have to remove one on the top. So it's not 50 out of 99, it's 49 out of 99.
No, you wouldn't remove them from the top because they were not in the top because they had never passed the bar.
But your example was 50 out of 100, right?
50 out of 100 passed.
And
So,
then you say that if for this example, you take one out of the bottom, so it will be 51 out of 100 or 49 out of, I'm not,
no.
I think there's something wrong with it.
Okay, well, at the point that somebody starts into the pathway program, they have never passed a bar exam. So they were never in the top, the numerator. They were in the bottom because they had taken a bar exam. That's the only way you could be a 1390 is to have taken one. So if we don't change the calculation standard, it would be 50 over 100 in this example. It'd be 50%. If once once one person, let's say, enters the pathway, we wouldn't add one or subtract one to the top because they weren't in there, but we would subtract one from the bottom because we would temporarily not be calling them a bar taker anymore while they're in the program.
Since we've had a robust discussion on this matter, is there a motion to adopt the proposed amendment to the guideline?
So moved.
Thank you, Dolores. Is there a second?
Second here by Robbie.
Thank you. Roll call vote, please.
Yes. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
No.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes, and thank you for the clarification, Paul.
Mr. Kaplan,
No.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Mr. Reyes,
No.
Judge Toriaba,
Yes.
Mr. Torres,
No.
Dr. Wilkinson,
No.
the motion passes.
Okay, then the final item on standards is the goals. I've reviewed them and I don't have any recommendations to change them. Does anyone have any questions or want to discuss any of them? If not, the recommended motion is to approve the goals.
This is Robbie, Paul. Thanks for a great, thorough job. I'm going to move to approve the goals for the committee.
This
I'll
is
second
Michael.
that.
Second by Judge David Torres.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Efting,
Yes.
Mr. Gongora, Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Isari,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
excuse me, Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Can you indicate a yes for me? My microphone switched when you called me. So I
Okay,
said, but I didn't hear me.
Thank you.
Thank you. So this actually concludes our open session. I think right now would be a good time to take a lunch break. And when we do resume, please have everyone go to closed session. Since we have time today, let's resume at 12:15. It's 11:40 on my clock right now. And we will begin closed session at 12:15. So again, go to closed session when we all meet again.
Thank you.
Thank you.
Thank you. We don't have to jump into public and then go into closed, or is this the notice that we typically do? Caroline?
No, we can just go after the lunch break. We can just start in closed. We're not going to be adjourning the meeting until tomorrow because closed session will continue into tomorrow. So we'll take an overnight recess in closed session, and then we'll adjourn the meeting tomorrow after closed session concludes.
Thank you.
Mhm.